The Media Institute, the foremost independent advocate for the First Amendment for over 4 decades, is one of the nation's leading nonpartisan organizations focused on media and communications policy. The Media Institute promotes freedom of speech, recognizes excellence in journalism, and encourages a competitive media environment and communications industry. Considering the current state of affairs in the nation's capital and across the country, our mission has never been more relevant. As we gather virtually for this month's Communications Forum, the Media Institute wishes to recognize our sponsors and supporters. APTS, ACA, AT&T, Charter, CTA, CPB, Covington, Cox, CTIA, Davis Wright, Disney, DLA Piper, HC2, Howard Stirk, iHeart, IAB, ION, Lehrman Center, LG, NAB, NBC Universal, NCTA, NMA, Nixon Peabody, Sinclair, Tegna, T-Mobile, US Telecom, Verizon, Viacom CBS, Wiley, and Wilkinson Barker Knauer. Thank you. And now the President and CEO of the Media Institute, Rick Kapler.
Hey, good afternoon, and welcome to our virtual Communications Forum Luncheon for August. We're happy to have you with us, and we have a terrific program for you today. Once again, I'd like to thank our luncheon sponsors who make this series possible. We truly appreciate your support, and our special thanks to John Taylor of LG Electronics and to Dave Ireland of Ireland Communications for producing these virtual luncheons. Let me say a word about next month's event. On Monday, September 21st, our speaker will be Charlie Cook, the well-known editor and publisher of the Cook Political Report and columnist for National Journal. He'll give us his predictions just 6 weeks before Election Day, and maybe a few thoughts on campaign media coverage and advertising strategies too. Charlie's presentation should be really entertaining as well as informative. And this will be a virtual event, and the date again is September 21st. At this time, I'd like to share some exciting news with you. Today, the Media Institute is officially launching a new program called the Digital Media Center. This center will examine, and we hope bring clarity, to issues at the heart of today's digital revolution, and it will offer a perspective on key digital issues with an eye toward the post-pandemic future. It will serve as a forum where experts from various digital, media, government, and academic sectors can engage with each other in ways that advance common goals and promote sound public policy. I'm happy to tell you that the Digital Media Center's program activities will be coordinated by the Media Institute's distinguished fellow, Stuart Brotman. We're very glad that Stuart is bringing his creative talents to this endeavor, and you'll be hearing a lot more about the Digital Media Center in the weeks to come. But right now, I'd like to tell you more about Stuart Brotman, who also happens to be today's speaker. Stuart just concluded a 1-year appointment as a fellow of the Woodrow Wilson International Center for Scholars in Washington, D.C. He was based in the center's Science and Technology Innovation Program, where he focused on digital privacy policy issues. He's one of the leading global experts in this area and has published widely on digital privacy and cybersecurity topics. In fact, Stuart has just published a new book titled Privacy's Perfect Storm: Digital Policy for Post-Pandemic Times, which is based on his work at the Wilson Center. In addition to his expertise in digital privacy, Stuart has a broad academic portfolio that includes law, communications, business, and public policy. He was a longtime member of the Harvard Law School faculty and currently holds 2 endowed chairs at the University of Tennessee at Knoxville. He also serves as an annual lecturer in entertainment and media law at Stanford Law School. Stuart is the editor or author of several books, including the treatise Communications Law and Practice. He has served in 4 presidential administrations on a bipartisan basis and is a former president and CEO of the Museum of Television and Radio. We've had the pleasure of working with Stuart for several years, And I'm very happy that this collaboration will continue with our Digital Media Center. And I'm especially glad that Stuart is with us today to share some of his insights on digital policy for post-pandemic times. Ladies and gentlemen, it is my great privilege to introduce the Media Institute's distinguished fellow, Stuart Brotman.
Rick, thanks so much for those very kind words, and I'm really enthusiastic about working with you and the Media Institute on developing an exciting, interesting digital media center. So this afternoon, what I'd like to do is to help you come on the journey that I've been taking in the world of digital privacy. Last year, on Labor Day, I moved to Washington, D.C. and took up residency at the Woodrow Wilson Center for International Scholars. I was awarded a fellowship in the Science and Technology Innovation Program, and I had the wonderful opportunity of being able to spend full time talking, thinking, and writing about digital privacy policy. What was interesting is that I came to the Wilson Center at a time that I call the beginning of a perfect storm. That began in May of 2019 when the European Union enacted something called the Gdpr, the General Data Privacy Regulation. Gdpr is the most sweeping privacy regulation ever enacted by government, in this case, all of the governments of the EU. And now that there's Brexit, the UK has even signed on to the Gdpr, even though the UK is no longer part of the European Union. So GDPR covers 28 European countries. And essentially what it means is any digital information that flows to or from Europe is covered by GDPR. And that's quite substantial because there are over 300 million residents in Europe. And obviously it affects companies outside of Europe that are exchanging information with Europe, which is virtually any major American company. So GDPR began what I am going to take you through, which is the perfect storm. As a result of that, the United States needed to figure out what it wanted to do. And the United States has no comprehensive federal legislation which is comparable to the GDPR. So what happened is that a number of states began individually to look at this area of digital privacy to see, because the United States government, the Congress was not acting, whether there was a potential role for the states to get involved. And the first and most prominent state that moved ahead was California, our largest state. California enacted a piece of legislation called the Ccpa, the California Consumer Privacy Act. And although it's not as comprehensive as GDPR, it essentially adapts many of the provisions, again, for data that is flowing inside or outside of California. It covers all California residents. So, for example, if you live in Los Angeles and if you happen to be traveling to New York and have data flowing onto your mobile phone, that's covered. You don't physically need to be in California. And that's comparable to what we see with the GDPR. You don't physically need to be in Europe as long as the data is flowing to or from Europe. So the CCPA was enacted. It took effect January 1st of this year, and then actually really didn't take effect until July 1st, because during that period, the California Attorney General, who will oversee the enforcement, had to essentially write many, many, many regulations, hundreds of pages of regulations. There was an open process for doing so. And in fact, even though July 1st was the date when all of these regulations took effect, they've not been published until relatively recently, a couple of weeks ago. Other states began to look at this and see whether or not GDPR or CCPA would be something that they might want to adapt. And so as I speak today, we have 20 states in the United States that are looking at different flavors of data privacy protection. And some of them are in the more advanced stage, some are less. A couple already have initiated actual legislation. Illinois, for example, has a biometric privacy act. So when your fingerprints or facial recognition is reduced into digital data, all of that information essentially becomes covered by the Illinois Privacy Act. And like California and Europe, it also has what's called extraterritorial impact, which means if that information moves with you, you're covered if you reside in Illinois. Maine has also enacted its own Privacy Act, and it has a little different flavor as well. In Maine, it covers the internet service providers. And so they are responsible for essentially collecting and disseminating data and will be subject to enforcement penalties as well. But most critically, the largest states in the United States as we speak, other than California, New York, Texas, Illinois, Florida, and Pennsylvania, all are now considering their own privacy legislation. And so when you add up the number of people who live in those states, that's substantially most of our population, or at least the majority of the US population. So those are the two initial elements of what I call the perfect storm. And of course, then we have the United States Congress, the 116th Congress, which is our current Congress. Congress has been paying very close attention to what's been happening in Europe and what's been happening in California and the rest of the states. And we have had a series of new pieces of legislation, and in some cases discussion drafts, that have been introduced both in the House of Representatives and in the United States Senate. Interestingly, both political parties have become interested in this area. And so we have had bills introduced by Republican legislators and other bills introduced by Democratic legislators. Unfortunately, we don't have a bipartisan consensus at this point. And so the two political parties and sides have had great difficulty in trying to reconcile their bills. There are some general principles I think that both of them accept. The first and most important is that individuals have a right to control the information that they're generating. And obviously that information gets generated in a variety of ways, certainly through e-commerce, through social media, through a variety of other digital mechanisms. Then typically there's an agreement that some group needs to be defined that would be covered by the law. And in the case of Europe, it's the broadest group. Europe covers just about any entity. It covers corporations. It covers nonprofit entities. It covers governments. So it's a very broad approach. The US approach, whether at the state level or at the federal level, is a little more narrow, but still quite broad. It covers companies, obviously companies of a certain size, and so the very smallest business would not be covered by it. But most of the companies that we deal with on a regular basis would be covered by this legislation. And then, of course, once you have the rights defined and the coverage, you need to create some procedures for enforcing that. And typically in the US legislation, the enforcement would be done by the Federal Trade Commission. Now, Senator Gillibrand from New York has introduced another bill. This is what is called the sixth bill. And she has a very interesting approach, but far different than the others. She has introduced a bill to create a new United States Digital Privacy Agency. So this would be a new agency. You could think of it as comparable to the Federal Trade Commission or the Federal Communications Commission. And in doing so, Senator Gillibrand has really looked to the European model. The way that European data privacy laws are enforced, the Gdpr, is through individual country data protection agencies. And so Senator Gillibrand says that she thinks that's the model that we should adapt. That has not gotten a great deal of traction so far, but it's an alternative to have an existing agency like the FTC be in charge. One thing that's very important to recognize is that you could write a really great bill, but you don't have enough money or enough resources to support enforcement. So for example, the Federal Trade Commission right now has about 1,000 people in its Consumer Protection Division. How many do you think are really looking at data privacy on a day-to-day basis? Well, the answer is 40 out of 1,000. And if you can imagine, since about 275 million people are connected to the internet, and if they had any sort of privacy issue, they would have to deal with the FTC, and there are only 40 people who can deal with it, we may have a real enforcement gap. I think in Europe, what we've seen since the adoption of the Gdpr is there are some real enforcement issues because there are not enough resources that essentially can implement the law. And so I think one important element whenever legislation is discussed is how much money is going to back it up. And certainly in our pandemic period, when we're going to have all sorts of financial stresses, I think it remains an open question whether or not Congress would be willing to allocate enough money, and obviously allocate it so that it's done on a long-term basis. But beyond that, there are two real sticking points in getting federal legislation passed now, and this is an absolute stalemate. The first is the notion of preemption. I've mentioned that a number of states, obviously California, Maine, and Illinois, but a number of others, are developing their own legislation. And so one question is, what happens when Congress comes in with federal legislation? Does that preempt, does that replace or negate the existing state legislation? Or is there a way to somehow integrate and meld the two systems, the federal system and the state system? That remains to be seen, and certainly is a point of great contention in Congress right now. The second area is called private rights of action. And private rights of action, in simple terms, is the ability to have a class action suit against a Google or an Amazon or another large company in terms of data privacy. There are some who say, no, this is really a federal responsibility. We should not have private rights of action. Obviously, we're going to see a mass amount of private litigation going on, which will deter companies from essentially putting in the right mechanisms and obviously create great financial difficulties. To some extent, that is a pretty persuasive argument looking at what we've seen in California so far. Since the Ccpa took effect July 1st, there are already over 170 class action suits that have been filed to enforce the Ccpa. Class action suits typically involve many, many people, typically in the hundreds of thousands or millions. The damages are very large. And so this is an existing point of great contention. On the other hand, we have a whole system in the United States of antitrust laws, which in fact allow private rights of action. And that system has been in place for over a century. It seems to be working pretty well. So we have the Department of Justice and the Federal Trade Commission that enforce our antitrust laws, but there are also private civil actions that can take place. And then in terms of preemption, there is no preemption in antitrust law. So we have federal antitrust law, the Sherman Act or the Clayton Act, but we also have state antitrust laws. And so individual attorneys general in those states can essentially sue under their state laws. So it's an interesting dilemma. Certainly, as I said, it's a stalemate at this point. And it looks like neither side is really willing to compromise those. And I'm not sure what the point of compromise might be. Let me just point out back to our friends in Europe, a major decision came out last month, which is called the Privacy Shield decision. This is the European Court of Justice. And essentially, what the European Court of Justice held was that a negotiated agreement that the United States had with the European Union on behalf of American companies which would have allowed American companies essentially to self-certify that they were complying with the European privacy law, that essentially was not allowed. And that was something called the Privacy Shield. And that has really amped up, I guess, the winds of this perfect storm, because now US companies are no longer protected by this agreement between the US and the European Union. And it remains to be seen whether or not a new type of privacy shield can be negotiated between the US and the EU that will be sustained by the European Court of Justice, or whether some other system will be put in place. Right now, as we speak, the US Department of Commerce is negotiating very aggressively with counterparts in the European Union to try to see whether or not they can save the European Privacy Shield. So stay tuned with that development. It's very important. So now let's talk about the third element of the perfect storm. And that third element obviously is COVID-19. So since the pandemic struck, we have all essentially retreated to our homes, our work. Obviously, we live there. And so the whole world has really changed, and the importance of digital data and the transmission, storage, and use by business and others has increased dramatically. And even post-pandemic, I think there's going to be a much larger importance for transmission and storage of digital data. And so what we've seen so far are new technologies like location tracking and contact tracing that have been pretty essential to COVID-19, but obviously are also technologies that can collect and store data, which is personal information. We also have a lot of unprotected networks. Since most of us are now at home and most of us do not have the comfort of having a large corporate network that you would in an office environment, we now have a much greater possibility that our existing data may be hacked by domestic actors or by foreign actors. And so that raises other possibilities. We also have obviously increased surveillance that's going on. In terms of our nation's unrest, we've had increased use by law enforcement of technologies like facial recognition, which is the ability to essentially photograph or take a video and digitize that, match that up against a variety of other databases. So there's a lot going on in terms of COVID-19. That's the perfect storm. GDPR, the states, Congress, and COVID-19. And so my book, Privacy's Perfect Storm, is intended to be a guide to help navigate through that perfect storm. And I spent the better part of the year thinking and writing and talking to virtually everyone involved in this area. The White House, Congress, people in the states, companies, think tanks, researchers. So I had what was called the 360-degree view of this, and it's been a great opportunity to be able to think very broadly and deeply about this area. So let's turn our attention to the 117th Congress, because we know that in January of 2021, that Congress will be in force. What's going to happen? Obviously, a lot of what may happen depends on which president is going to be in office. So let's at least look at the two options. First is President Trump. If President Trump is reelected, the Trump administration has shown very little interest in pushing federal privacy legislation. They've essentially said to Congress, this is something that you can work out. If you work out something and bring it to the president's desk, there's a high likelihood that the president will sign it. But the administration has not been very active in terms of those negotiations, in terms of drafting its own legislation. So based on that, it may be difficult to forecast an optimistic scenario for federal legislation. If that's the case, I think we're going to have much more activity, certainly accelerated activity at the state level, those 20 states I talked about, and certainly more states may come into the picture. If there is a President Biden, what will that situation look like? So with a President Biden, I think there would be a focus on trying to get a piece of legislation through the 117th Congress, probably in the early stages, meaning the first year, because typically when the new president comes into office, the new president wants to have some quick, successful legislative action. And there's a real possibility here that that could take place. Also, Vice President Biden has enormous legislative experience and prides himself on bipartisan relationships. So to the extent that the stalemate between Republicans and Democrats needs to be bridged, probably Vice President Biden would look at that as a challenge and pursue that quite vigorously. So those are the two possibilities. But there's a wild card here. That wild card, if the Biden administration takes office, would be Vice President Kamala Harris. And the reason is because Kamala Harris was the Attorney General of California, the state that has the Ccpa. She was very instrumental working with the California legislature in getting that piece of legislation drafted and is very familiar with this area. And so she may take a much more active role. She may be delegated by a President Biden to essentially oversee this. On the other hand, she has great sensitivity to have the states be involved in this. And so she may be less active or less assertive in terms of saying we need to have the federal government preempt. She may say this is something that California and the other states should continue to do. And then there's one other wild card which is taking place in California, and that's called Proposition 24. So in November of this year, election year, the California voters will essentially decide on a proposition which will essentially put into the new law the California Consumer Privacy Act, the CCPA, but will strengthen it and will add more financial penalties, and more critically, like Senator Gillibrand and like the Europeans, would create a separate independent agency, the California Data Protection Agency, that would administer the new law. What's important about the ballot initiative is that it can't be overturned by a legislature. It can only be overturned by the voters. And that gets us back to Kamala Harris. The Biden-Harris administration, if there is one, might be very unwilling or less willing to overturn the will of the California voters if they approve Proposition 24. So that makes it a very complicated situation. The last thing I will mention now is the international front in terms of our trade agreements, because they're implicated in this perfect storm as well. So earlier this summer, the United States finalized the United States-Mexico-Canada agreement. That's the successor to NAFTA, the North American Trade Agreement. It has a number of provisions that deal with data privacy. And very interestingly, it doesn't have a provision that applies to all of those countries. It says for each of those countries, the agreement will look to the domestic situation in the United States, in Canada, and in Mexico. Canada and Mexico have federal legislation in place now. The United States does not. And so it's going to be interesting as USMCA, the US-Canada-Mexico-Canada agreement is implemented, how that will be implemented when two of the countries have laws in place and one doesn't. It's not a requirement that all of them have laws in place. They have to have essentially principles that they're willing to agree on. But the United States may be in a less beneficial situation because it doesn't have a law that it can talk about. Well, that's just a very, very quick summary of this world. It's a complicated world. It's a world that's going to affect all of us. It's certainly a world that is implicated by our current pandemic and our thinking about the future. And it's something that will play out very firmly as elections take place, as we have a new Congress and a new administration. So I'll end there, and then hopefully we'll have questions, and I'm happy to talk about anything related in this area. Thanks so much.
Hey, Stuart, thank you so much. That was a fascinating presentation. Boy, you covered a lot of ground there in incredible detail, and what a great education for all of us. Let's get right to some questions here. The first one comes from our good friend Adonis Hoffman. Adonis says, as companies seek to reconcile their practices with Gdpr and Ccpa, are there any inherent conflicts between the two privacy regimes or other state laws?
Well, that's a great question. The short answer is yes. And let me give you a few illustrations just to show you the tension between some of these laws. The GDPR, you could think of, this is the European law, as being a far broader law than the state laws in the United States, such as the Ccpa. So for example, the GDPR covers not-for-profit entities. It covers political campaigns. It covers government. Whereas Ccpa really is focused on commercial entities. And so there's a real difference in terms of the amount of coverage. Then, of course, there are people who might be covered by both laws. So, for example, you may have a resident in California who also is a citizen of the EU. And both of these laws have what's called extraterritorial effect, which means that you don't physically need to be in a place for them to take effect. That means if your European GDPR is in force in California, if you are a citizen of Europe, and also if you're a Californian who happens to be traveling outside of the state and maybe traveling to Europe, that law would apply. So there may be an inherent conflict between the two in terms of which law would apply under the circumstances where you have these dual situations. Let me talk a little bit about some other state laws just to illustrate another potential conflict. So other than California, which obviously is the largest state, there are a few other states which already have enacted privacy laws. Probably the most notable other than California is Maine. So Maine has a very interesting privacy law in that it only covers internet service providers, whereas the Ccpa would have a much broader reach. It would cover data brokers, it would cover companies like Google and Amazon and Facebook, but those are not internet service providers. So again, we see this distinction between broader coverage and more narrow coverage. That's one of the, let me give you one other quick illustration, Illinois. So Illinois does not have a comparable state privacy law similar to either Maine or California. It has some laws that are being discussed now, but it did pass a separate biometric act. And so that covers things like facial recognition and fingerprints and any biometric information. So again, we see that you can have a very tailored approach to a privacy law, which may inherently conflict with a broader approach, such as GDPR or Ccpa. And it's really one of the arguments, I think, that people raise in terms of having federal legislation, at least in the United States, saying in order to reconcile some of these inherent conflicts and not create what's called the patchwork quilt of state laws, perhaps the argument should be that we should have one federal law which would at least minimize some of these inherent conflicts.
Okay. Stuart, what's your view on cancel culture and the rush to restrict social media speech? In the United States, do you think privacy has trumped the First Amendment?
Well, again, we have interesting tensions and conflicts going on. I don't think there's a fundamental conflict here. I mean, typically, there are a number of people, obviously, who are anonymous speakers. One of the great freedoms you have on being online is you could be anonymous or you could be your dog. So in terms of identities, a lot of people can continue to speak without revealing any personal information. So there may not be that level of conflict between the two.
Okay. Is there a chance that a Biden administration would seek to bring digital privacy back under the control of the FCC? Or has that ship sailed?
Well, that's very interesting. We've had obviously a complete reversal under the Biden administration of what was called net neutrality. The Biden administration and obviously the majority of the commission enacted the Internet Freedom Order, which essentially reversed course so that the jurisdiction for privacy now is not at the FCC, it's back at the Federal Trade Commission. In the platform of the Democratic Party, and I believe Vice President Biden is on record, I think he favors the restoration of net neutrality. And if that's the case, then the question is, would we revert to the previous situation that we had certainly under Chairman Wheeler? And would the new net neutrality order be identical to the previous order? We don't know that. We know the concept probably would be similar, but it remains to be seen whether or not the FCC would then assert that level of authority. And I think at this point, totally unknown, but I would suspect that there's probably a greater push for the reinstatement of net neutrality under President Biden than there is under President Trump, because obviously President Trump wanted to get rid of it.
And how do you think these new privacy developments will impact media companies and advertising?
In profound ways. Obviously, we see a number of media companies, virtually all media companies, have their people working at home now during COVID. And so those people who are working for media companies are now sort of intermingling personal information with company information. They're using their personal devices, not company devices. They're often on personal networks and not on company networks. And so now we have, I think, greater vulnerability, certainly in terms of hacking, in terms of having sensitive information. Remember, a few years ago, one of the major media companies, Sony, had one of the biggest hacks in the history of cybersecurity. And thousands, actually millions of its records were essentially taken and posted. And so we have a very serious situation, I think, in the media community, particularly because many of those emails and other information truly is proprietary and sensitive. And to the extent it leaks out, whether inadvertently or through some sort of hack, that has profound implications for media companies. The other element, obviously, is as media companies essentially are communicating much more intensively with their customers now through streaming and other media, it means that they're going to become much more reliant on gathering information about those audiences and about those customers. And anytime you do that, that will implicate what's called personally identifiable information, which is the type of information that's restricted under the state laws and would be under federal law.
Now, going back to federal legislation for a minute, you mentioned that there were a couple of sticking points to arriving at a piece of federal legislation, one being the question of preemption, whether this federal legislation would override this sort of patchwork of state laws, and the private right of action for individuals to bring class action suits. Now, are those sticking points breaking down according to party lines, or is there some other fault line there?
Well, roughly they are party lines. I would say if you were going to characterize it, the Republican philosophy would be to restrict private rights of action. And certainly the idea of preemption, we have a states' rights issue, but I think the notion there would be to have a much more federal approach. What's interesting here is that on the Democratic side, a number of people there actually would not necessarily want to have a preemption because some of the states are very powerful politically. Some of them obviously are large Democratic states, including California. So as a political matter, it's very difficult to go back to the voters in a particular state, particularly in California, which will be voting on an enhanced CCPA in November. It's called Proposition 24. But if that's approved and you have federal preemption, that essentially means that the votes of Californians would essentially be negated by that legislation. And that might not be something that sits very well in California. And if you have a change of administration and the sitting vice president is Kamala Harris, who comes from California, and in fact, as Attorney General, was instrumental in drafting the CCPA, I think it may raise some more tension on the Democratic side than the Republican side.
We have time for one final question. I want to ask you, in your book, you talk about getting back to, again, federal legislation, that you don't see a silver bullet solution to privacy problems right now, a silver bullet being one piece of federal legislation. But instead, you mentioned that the answer might be more along the lines of what you call a multi-stakeholder digital privacy policy toolkit. I wonder if you could just briefly comment on that and what might be in this toolkit.
Yeah, that's a mouthful, but essentially what I've done is I've looked at comparable areas, obviously more health related, but when we tackle a big area in the country, the United States at least, from a public policy standpoint, law and regulation typically doesn't get you all the way. Typically, we need to build in social and cultural aspects of this as well. And one of the illustrations I always give is driving under the influence, DUI, drunk driving. An enormous problem that we have had in this country, but statistically it's gone down dramatically. Why is that the case? Well, certainly we had some great legislation. We've had the drinking age that's been raised. We now have a national standard for a blood alcohol level, but that in itself is not necessarily going to reduce driving under the influence. You need other things involved. So at the local level, you needed police departments to be able to have breathalyzers, and you needed money allocated by local officials to do that. We had car manufacturers who came in and essentially developed systems where ignition locks could be correlated with your alcohol level. And so if you were not able to drive, your car wouldn't turn on. Obviously, we had groups like Mothers Against Drunk Driving who mobilized nationally in communities to try to get the word out about the dangers of driving under the influence. We had education reform. Now in health classes and phys ed classes across the country, students are taught about the dangers of alcohol and alcohol abuse. We had the Center for Disease Control involved in funding more. We had the Advertising Council now doing ads. So what I'm suggesting here is there's a broad range of things that we can and probably should be doing. And although law and regulation is important and may be a starting point, I don't think it's the end point.
Stuart, thank you so much. What an excellent presentation. And we're really grateful to have you with us today. And we certainly look forward to working with you at the Digital Media Center. And we have some great things ahead there. So thank you again for your excellent presentation today.
Absolutely. It's a real pleasure. Thanks so much.
And I want to talk to our sponsors for a minute just to say that we have a special offer for you. Stuart's book, Privacy's Perfect Storm, is available now, and we are going to give a free copy of that book in Kindle version to all of our Luncheon sponsors. So we'll be in touch with you about that, but we feel this is an important book and we want you to have a copy of it. And just another way that we can thank you for your support of this Luncheon series as well. So thank you again, Stuart. Thank you to our sponsors for making this series possible. Thanks to Arlen Communications and LG Electronics. And thank you all for being here today. Please join us again on September 21st, when our guest will be political analyst Charlie Cook. Thank you for being here. Have a good day.
Thank you to our special guest speaker today. Thank you to the Navy Band. And thank you again to our sponsors. See you next month.